Okay, ang recording na to ay tungkol sa Post-Judgment Remedies Part 2. Ito ulit si Attorney Chato Olivas Quinto. Dun sa Part 1 ng video on Post-Judgment Remedies, diniscuss natin dalawang remedies. Motion for reconsideration and motion for new trial. Sa video na to, ang i-discuss natin yung mga iba pang available post-judgment remedies. Gusto ko lang i-clarify na dalawang categories ang post-judgment remedies. Una, yung remedies na pwede mong i-file within the 15-day appeal period or within 15 days from receipt of the decision. At yung pangalawang klaseng remedies are those that you can file after the 15-day appeal period. So dun sa 15-day appeal period, ang mga pwede mong i-file ay ang mga sumusunod. Number 1, motion for reconsideration, which we discussed in video number 1. Motion for a new trial, which we also discussed in video number 1. Next, you have appeal by notice of appeal with record on appeal in certain cases. And next, petition for review. And the last one is appeal by certiorari, also known as petition for review on certiorari. So wag niyo i-confuse ang petition for review dun sa appeal by certiorari or petition for review on certiorari. Kasi ang petition for review is an appeal from RTC to CA or appeal from quasi-judicial bodies to the CA, whereas yung appeal by certiorari or petition for review on certiorari is to the Supreme Court from the RTC, CA, CTA, Sandigan Bayan. And this deals only with pure questions of law. So balik tayo dun sa mga appeal by notice of appeal or with record on appeal in certain cases. Kailan to gagawin? If the court of origin is the MTC and the appeal is filed with the RTC, you appeal by notice of appeal. If the court of origin is the RTC and you appeal to the CA, the appeal is by notice of appeal. In certain cases, kailangan ng record on appeal in certain special proceedings. So, ang ibig sabihin ng record on appeal, ito yung parts of the case files that will be forwarded to the appellate court. Okay? Only in certain special proceedings because the general rule is hindi lang yung part ng record ng ifo-forward sa appellate court but the whole case files. Okay? So, now, from MTC to RTC, notice of appeal, this is a short notice. This is about, it's in length, no? About 1 or 2 pages na nakalagay lang doon that the party is appealing the decision of the MTC to the RTC. And then, pag RTC naman, it is just a 2-page notice stating that the party is appealing the decision of the RTC to the CA. Yung petition for review naman, eto, from dalawang klaseng petition for review. Una, from the RTC to the CA, but this time, the decision of the RTC was rendered in its appellate jurisdiction, meaning it was the MTC that had original jurisdiction and then rendered the decision, and the decision was appealed to the RTC, and the RTC decision is now being appealed to the CA. Hindi ito notice of appeal. Ito ay petition for review under Rule 42. The other kind of petition for review is from quasi-judicial bodies to the CA under Rule 43. Okay? So itong appeal by certiorari, na-discuss na natin ng konti kanina. Now, punta tayo dun sa remedies that you can file after the 15-day period of appeal. You have 3 remedies. Number 1, petition for relief from judgment under Rule 38. Number 2, action for annulment of judgment, order, or resolution of the RTC. Now, this is filed as an original action with the CA. Okay? Hindi ito appellate. This is an original action, but it is a post-judgment remedy because it is a decision that is rendered after the RTC has already rendered a decision. In the same way, pwede rin ipa-annul yung decision ng MTC under Section 10 of Rule 47. So ito, action for annulment of judgment, either the judgment of the RTC, which is filed with the CA, or the judgment of the MTC, okay, which is now filed with the RTC. Okay, so And then the third kind of post-judgment remedy is petition for certiorari under Rule 65. Gusto ko lang ilinaw, as a general rule, ang Rule 65 petition for certiorari is not a post-judgment remedy. It is an original action and it is in fact a special civil action. As an exception, with respect to final judgments, orders, or resolutions of the COMELEC and COA, a petition for certiorari under Rule 64 in relation to Rule 65 is a post-judgment remedy. Okay, pag-aaralan natin yan. So, umpisahan na natin. Appeal by notice of appeal or with record on appeal in certain cases from MTC to RTC. This involves a final decision, order, or resolution of the MTC. Kailangan mag-file ng notice of appeal with the MTC plus pay the docket fees. Kasi kung hindi binayaran yung docket fees, the appeal will not be considered to have been perfected. The caption of the case on appeal is the same as that of the case in the MTC. Kaya lang dadagdagan ng designation yung parties with the words appellant or appellee as the case may be. So for example, XYZ plaintiff appellant versus ABC defendant appellee. When do you file this? You file this within 15 days from receipt of the final decision, order, or resolution. Kaya lang in special proceedings, when a record on appeal is required, it will take a longer time. So the appeal period is 30 days. And the MTC will have to approve the record on appeal. Now, you serve the notice of appeal on the adverse party para alam na niya that you are appealing the case. Okay? So, and then the MTC will transmit the full case records, including the transcript of stenographic notes and evidence to the RTC. Once that is done, the clerk of court of the RTC will notify the parties that they have received the case records. And what is the next thing for the appellant to do? He should file a memorandum. Otherwise, the court will dismiss the appeal. Okay, yung appellee naman may file an appellee's memorandum within 15 days from receipt of the appellant's memorandum. After that, the case will be submitted for resolution. If the appeal is taken from an order of the MTC, okay, ayusin lang natin to, from an order of the MTC, dismissing the case for lack of jurisdiction without a trial on the merits, the RTC may affirm or reverse the MTC decision. If the RTC reverses the dismissal and makes a finding that the MTC has jurisdiction over the subject matter, the RTC will remand the case to the MTC for further proceedings. But if the RTC affirms the dismissal and makes a finding that it is the RTC that has jurisdiction over the subject matter, the RTC will try the case as if it was originally filed with the RTC. Okay? Now, dako naman tayo sa appeal by notice of appeal or with record on appeal in certain cases, and this time from the RTC to the CA. The governing rule is Rule 44. Now, it should also refer to a final decision, order, or resolution of the RTC. Ibig sabihin, pag dinismiss ng RTC yung case on the basis of an affirmative defense, for example, and that dismissal can be the subject of a notice of appeal because it is final. Kaya lang, it's not going to be a decision but an order of dismissal. Pwede yung i-appeal. What to do? File a notice of appeal with the RTC and pay the docket fees. Same rule on caption and title, but add appellant and appellee as the case may be. The counsel and guardians ad litem of the parties in the court of origin shall be considered as counsel and guardians ad litem in the Court of Appeals. And the notice of appeal must be filed within 15 days from receipt of the decision, final order, or resolution. Ganon din, katulad din nung sa MTC, if a record on appeal is required 30 days. The RTC will approve the record on appeal. So kapag sufficient yung appeal, meaning nag-file ng notice of appeal on time, the docket fees were paid, the RTC will now forward the full case records to the CA. CA will notify the parties when the records have been received from the RTC. And this time, hindi memorandum. The appellant shall file the appellant's brief within 45 days from notice from the Court of Appeals. Importante, according to the rules, that the appellant must look at the records of the Court of Appeals and make page references to the records. So yung number nung pages in the records of the Court of Appeals, yun yung dapat i-cite dun sa appellant's brief. Now, the appellee has 45 days from receipt of the appellant's brief within which to file an appellee's brief. And from that time, the appellee may file a reply brief within 20 days from receipt of the appellee's brief. So 45, 45, and 20. Okay. Certiorari prohibition, mandamus, quo warranto, and habeas corpus cases. In these cases, the parties shall file in lieu of briefs their respective memoranda within a non-extendable period of 30 days from receipt of notice issued by the clerk that all the evidence, oral and documentary, is attached to the record. The failure of the appellant to file his memorandum within the period may be a ground for dismissal of the appeal. Anong questions ang pwede mong i-raise on appeal? The appellant may include in his assignment of errors any question of law or fact that has been raised in the court below and which is within the issues framed by the party. So isang requisite, dapat dinaanan ng court below yung issues that you are going to raise on appeal. Hindi pwedeng you will raise an issue for the first time on appeal. Okay, that is important. Let's go to petition for review. Okay, magkaiba ang notice sa petition. Pag sinabi nating notice, it is a matter of right. Kaya nga nino-notify lang ng appellant yung court and other parties na mag-a-appeal siya because it is a matter of right. Pagdating sa petition, okay, this is a matter of discretion on the part of the court. So, the appellant or the petitioner in this case will have to convince the court that it is worth reviewing the decision. Kaya siya tinatawag na petition at hindi notice. Nakikiusap siya, nakikisuyo siya, please review my case. All right, so there are two kinds of petitions for review. Letter A, from RTC to CA on decisions rendered by the RTC in its appellate jurisdiction. And the second one is from quasi-judicial agencies to the CA. Okay? So sinabi ko na to kanina, this is a petition, not a notice. And this is not a matter of right. Okay? It is a matter of discretion. Next, the petitioner files the petition directly with the court that will review the decision, in this case, the CA. In contrast, yung notice of appeal is filed with the court that rendered the decision. Okay? Again, para lang hindi nyo makalimutan, yung petition for review, file it with the appellate court. Yung notice of appeal, file it with the court of origin. Okay? Now, the designation of the parties are different. Petitioner and respondent. Okay? So, and then the petition must be verified and the docket fees must be paid. Next, a certification of non-forum shopping is required. Hindi na to required sa notice of appeal. So, in this petition, it is required. And a copy of the petition must be served upon the adverse party before filing it with the Court of Appeals. The CA may require the respondent to file a comment within 10 days from notice. Important, certified true copies of material portions of the records must be submitted to the court. Note that this is not like an ordinary appeal where the whole case file is forwarded by the RTC to the CA. The CA may set the case for oral arguments or require the parties to file memoranda within 15 days from notice. After that, the case will be submitted for decision. Let's go to appeal by certiorari or petition for review on certiorari under Rule 45. The court of origin here is the RTC, CA, CTA, Sandigan Bayan, okay? And the appeal is to the Supreme Court on pure questions of law. File a petition for review on certiorari which must be verified and may include an application for writ of preliminary injunction or other provisional remedies. Again, because this is a petition, this is really a petition, it is not a matter of right. It is discretionary upon the court. You file this within the 15-day period to appeal, pay the docket fees, and there must be a statement of material dates. Ano to? Ito yung date kung kailan natanggap yung original decision, kung kailan nag-file ang motion for reconsideration, okay, and then kung kailan i-final yung petition for review, yung appeal by certiorari. Okay? Now, you must also attach certified copies of the judgment, final order, or resolution that is subject of the petition. May mga kasong nadi-dismiss for failure to comply with this requirement. Okay, why will you attach? Because the case files are not forwarded in full to the Supreme Court. Only those copies that the petitioner attaches to the petition. Okay, at saka yung question, yung judgment, final order, resolution na kino-question dapat certified copy. What are the grounds for review that the SC may consider? Well, number one, when the court a quo has decided a question of substance not theretofore determined by the Supreme Court, or has decided it in a way probably not in accord with law or with the applicable decisions of the Supreme Court, or when the court a quo has so far departed from the accepted and usual course of judicial proceedings, or so far sanctioned such departure by a lower court as to call for an exercise of the power of supervision. The SC may require that the whole records or parts of it be elevated. Let's go to post-judgment remedies that you can file after the 15-day period to appeal. We have number one, petition for relief from judgment under Rule 38. Number two, action for annulment of judgment or the resolution of the RTC filed as an original action with the CA. Number three, action for annulment of judgment or the resolution of the MTC filed with the RTC. And number four, petition for certiorari under Rule 65 only with respect to COMELEC and COA decisions. Okay, punta tayo sa petition for relief from judgment. Now, this is again verified. Now, the judgment or final order is entered or any proceeding taken against a party in court through fraud, accident, mistake, or excusable negligence. Therefore, your ground for a petition for relief should be that there was fraud, accident, mistake, or excusable negligence. Sa procedural law, sa remedial law, pag sinabing fraud, ang ibig sabihin nito ay extrinsic fraud. Such fraud that prevented a party from exercising his right to procedural due process. Hindi tinutukoy nito ang intrinsic fraud, which is the intrinsic validity of a document. Hindi yon. Procedural due process ang tinutukoy ng extrinsic fraud. Now, file a petition in such court and in the same case praying that the judgment, order, or proceeding be set aside. Okay? A verified petition for relief from denial of appeal. This is the second kind of petition for relief. A judgment or final order is rendered by a court in a case and a party thereto by fraud, accident, mistake, or excusable negligence has been prevented from taking an appeal. File a petition in such court and in the same case praying that the appeal be given due course. When do you file this petition? May dalawang periods that you have to reckon with, 60 days and 6 months. So file the petition within 60 days after the petitioner learns of the judgment, final order, or other proceeding to be set aside, and not more than 6 months after the judgment or final order was entered or such proceeding was taken. Dapat yung dalawang periods na to must concur. What must be contained in the petition? The petition must be accompanied with affidavits showing the fraud, accident, mistake, or excusable negligence relied upon, and the facts constituting the petitioner's good and substantial cause of action or defense as the case may be. The court will order the adverse party to file an answer within 15 days from receipt. Okay, and the order shall be served in such manner as the court may direct, together with copies of the petition and the accompanying affidavits. Preliminary injunction, pending proceedings. Pwedeng magbigay ang court ng preliminary injunction as may be necessary to preserve the rights of the parties. Pero dapat yung petitioner will file a bond. Condition that if the petition is dismissed or the petitioner fails on the trial of the case upon the merits, he will pay the adverse party all damages and costs that may be awarded to him because of the issuance of such injunction or other proceedings following the petition. But such injunction shall not operate to discharge or extinguish any lien which the adverse party may have acquired upon the property of the petitioner. What happens after the answer is filed? Magkakaroon ng hearing. The court will conduct a hearing. If it finds that the allegations in the petition are not true, that there was no fraud, accident, mistake, or excusable negligence, the court will dismiss the petition. But if it finds that the allegations are true, it will set aside the judgment, and the case shall stand as if the judgment, order of proceeding had never been rendered, issued, or taken. At anong gagawin ng court? Since it is as if there was no proceeding, the court will hear and determine the case as if a timely motion for a new trial or reconsideration had been granted by it. What is the procedure where the denial of an appeal is set aside? The lower court shall be required to give due course to the appeal and to elevate the record of the appealed case as if a timely and proper appeal had been made. The next kind of action is an action for annulment of judgment, order, or resolution of the RTC, filed as an original action with the CA. Okay. This rule shall govern the judgments of the Court of Appeals, govern the annulment by the Court of Appeals of judgments or final orders and resolutions in civil actions of the RTC, for which, ito importante, the ordinary remedies of new trial, appeal, petition for relief, or other appropriate remedies are no longer available through no fault of the petitioner. Okay, hindi na pwedeng mag-appeal, hindi na pwedeng mag-petition for relief ang petitioner, but it is not through his own fault. For example, nalaman ng petitioner about the judgment of the RTC mga 2 years after it was actually rendered. So, hindi na available yung mga remedies na yon. Pwede pa niyang i-file itong Rule 47, Action for Annulment of Judgment. Okay? Grounds for annulment. Ito, dalawa lang. Extrinsic fraud and lack of jurisdiction. Extrinsic fraud shall not be a valid ground if it was availed of or could have been availed of in a motion for a new trial or petition for relief. Meaning, no, there was still time to file at alam na nung petitioner that such a decision was rendered, he could have filed a petition for relief on the ground of extrinsic fraud. Pero kunyari nga, 2 years after the decision, dun lang niya nalaman na meron palang decision, then he can bring this action on the ground of extrinsic fraud. Okay? Period for filing. Now, eto dalawang periods ito. If based on extrinsic fraud, the action must be filed within 4 years from discovery. And if based on lack of jurisdiction, before it is barred by laches or estoppel. Okay. So, bibigyan ko kayo ng halimbawa ng extrinsic fraud kasi in one of the cases that I handled, nangyari ito. Okay. A client came to me saying na she discovered that her marriage had been declared null and void and based on Article 36 of the Family Code at hindi niya alam. And it has been several years, 4 years already from the time that it was rendered, dun lang niya na-discover. Okay? Now, or less than 4 years rather, dun lang niya na-discover. And nung tinignan namin yung records, nakalagay doon that summons was served upon my client, okay, through a representative at a certain address. Pero ang totoo, hindi naman doon nakatira yung client ko at saka hindi naman niya representative yung taong yon. So because of that misrepresentation, she was not allowed, she no longer had the opportunity to present evidence. Na-deprive siya ng opportunity niya to participate in the proceedings. And because there was extrinsic fraud, talagang sinadya nung ex-husband niya or nung husband niya na hindi siya personally ma-notify at mag-proceed yung case up to final judgment. So, nag-file kami ng action to annul the declaration of nullity on the ground of extrinsic fraud, which was granted by the Court of Appeals. Okay, now let's go to, the other ground is lack of jurisdiction. And this must be filed before it is barred by laches or estoppel. So wala siyang number of years. Basta ang importante before it is barred by laches or estoppel. Ang lack of jurisdiction dito ang pinag-uusapan is lack of jurisdiction over the subject matter. Now, contents, filing and contents of the petition. Because it is a petition, it must be verified. Basta yun yung tatandaan ninyong rule. Because a petition is discretionary, okay, upon the court, then it must be verified. Of course, it must allege the facts and the law and supporting the petitioner's good and substantial cause of action. And then, parang yung other rule din sa petition for review, submit a certified true copy of the judgment or final order or resolution. Attach it to the original copy of the petition intended for the court. The petitioner shall also submit affidavits of witnesses or documents supporting the cause of action or defense. I-submit mo tong affidavit together with the petition. And then there must be a certification against forum shopping. Basta pag may petition, may certification against forum shopping. Now, what will the court do? Should the court find no substantial merit in the petition, it may dismiss the case outright with specific reasons for dismissal. But if it finds prima facie merit in the petition, the same shall be given due course and summons shall be served on the respondent. Bakit summons? Because this is really an original action. And then the procedure. The procedure in ordinary civil cases shall be observed. If a trial is necessary, reception of evidence may be referred to a member of the court or a judge of the RTC. What is the effect of the judgment? The judgment of the CA, a judgment of annulment shall set aside the question, judgment, or final order or resolution and render the same null and void. Kasi nga, this is an action to annul the judgment without prejudice to the original action being refiled in the proper court. But if the judgment or final order or resolution is set aside on the ground of extrinsic fraud, the court may, on motion, order the trial court to try the case as if a timely motion for a new trial had been granted therein. Okay? Suspension of prescriptive period. The prescriptive period for the refiling of the aforesaid original action shall be deemed suspended from the filing of such original action, meaning Rule 47 original action, until finality of the judgment of annulment. However, the prescriptive period shall not be suspended where the extrinsic fraud is attributable to the plaintiff in the original action. Relief available. The judgment of annulment may include the award of damages, attorney's fees, and other relief. If the question, judgment, or final order or resolution has already been executed, the court may issue such orders of restitution or other relief as justice and equity may warrant under the circumstances. Now, the same kind of action may be filed with respect to the decision, order, or resolution of the MTC. This action shall be filed with the RTC having jurisdiction over the MTC, and it shall be treated as an ordinary civil action. Now, petition for certiorari. Sinabi natin as a general rule, this is not a post-judgment remedy. It is an original special civil action. But with respect to the final judgments, orders, or resolutions of the COMELEC and COA, a petition for certiorari under Rule 64 in relation to Rule 65 is a post-judgment remedy. So the scope. Ang scope nito are judgments, final orders, or resolutions of the Commission on Elections and the Commission on Audit. Okay? And the mode of review is that a judgment or final order or resolution of the Commission on Elections and the Commission on Audit may be brought by the aggrieved party to the Supreme Court on certiorari under Rule 65, except as herein provided. Time to file the petition within 30 days from notice of the judgment or final order or resolution. The general rule for a petition for certiorari under Rule 65 is that the filing of the petition shall be within 60 days from notice of the judgment or final order. But if it involves decisions of the Commission on Elections and Commission on Audit, the period shall not be 60 days but 30 days. The filing of a motion for a new trial or a consideration of said judgment or final order or resolution, if allowed under the procedural rules of the COMELEC or COA, shall interrupt the period fixed herein, meaning the 30-day period for filing the petition. If the motion is denied, the aggrieved party may file the petition within the remaining period, but shall not be less than 5 days in any event reckoned from the notice of denial. Same as the others, upon filing of the petition, the petitioner must pay the docket fees and other lawful fees and deposit an amount for costs. Again, same as the others, the petition must be verified. Note, the petition shall name the aggrieved party as petitioner and shall join as respondents the commission concerned and the person or persons interested in sustaining the judgment, final order, or resolution a quo. The petition shall state the facts with certainty, present the issues involved, set forth the grounds and brief arguments relied upon, and pray for judgment annulling or modifying the questioned judgment, final order, or resolution. Okay? Ang question dito na ipapresent is whether there is grave abuse of discretion or lack of grave abuse or lack of jurisdiction, okay, with respect to the COMELEC and COA that rendered the decision. Yun lang. Findings of fact supported by substantial evidence shall be final and non-reviewable. In contrast, in other forms of appeal, you can question findings of fact and questions of law. Pero under Rule 64 in relation to Rule 65, dapat only when there is grave abuse of discretion or lack of jurisdiction. Now, the petition shall be accompanied by legible, duplicate, original, or certified true copy of the judgment, final order, or resolution. Yan, katulad din ng mga ibang petitions, dapat may certified true copy ng order, judgment, or final or resolution being questioned. And then material portions of the records which you will be referring to, dapat may certified true copies din. And then meron ding statement of material dates. Katulad dun sa kanina, petition, you must show when was the decision originally rendered, when was the motion for reconsideration filed, and when was the petition filed with the Supreme Court. Now, the petition shall be accompanied by proof of service of a copy thereof on the commission concerned and on the adverse party, plus timely payment of docket and other lawful fees. If you fail to comply with these formal requirements, it shall be a sufficient ground to dismiss the petition. If the Supreme Court finds the petition sufficient in form and substance, o-orderan niya yung respondent to file comments within 10 days. Otherwise, i-dismiss niya yung petition if it is for lack of merit, okay? The court may also dismiss the petition if it was filed manifestly for delay or questions raised are too unsubstantial to warrant further proceedings. Comment of respondents, the original shall be accompanied by certified true copies of such material portions of the records as are referred to therein together with other supporting documents. The requisite number of copies of the comments shall contain plain copies of all documents attached to the original, and a copy thereof shall be served on the petitioner. No other pleading may be filed unless required or allowed by the court. So pag sinabi ng court, comments lang, you cannot file any further pleading. What is the effect of filing? The filing of a petition for certiorari will not stay the execution of the judgment, final order, or resolution sought to be reviewed unless the court shall direct otherwise. Submission for decision, unless the court sets the case for oral argument or requires the parties to submit memoranda, the case shall be deemed submitted for decision upon filing of the comments on the petition or such pleadings or papers as may be required or upon expiration of the period to do so. So dito nagtatapos ang ating discussion on post-judgment remedies part 2. If you have questions, lagay nyo lang sa comment box. I will make sure that I will respond. And again, if you need a copy of my handout, I'm very much willing to provide you with one. Just send me a message through the comment box. See you at the next video.